Okay, guys, I've been working in estates and probates for something over 27 years now. And what I've found is that most Oklahomans don't have any estate planning at all. Not a power of attorney, not a will, not a trust. And when they die, which we're going to die, it's a mess. It's a free for all. The family is fighting. Some of them are stealing. Nobody knows who's going to be in charge or who ought to be in charge. Nobody knows what you wanted. It's a mess. So this video is to tell you kind of the minimum you can do and how easy it is to do it. Oklahoma recognizes holographic wills. In its easiest form, a holographic will is a will that you write by hand yourself. But of course, like everything else, there's a little bit more to it than that. It does have to be handwritten by you. It also needs to be signed and dated. It's best if it's signed and dated at the bottom, but you don't even have to do that. The reason I like it being signed and dated at the bottom is it's easy to show the judge that it was all there at the same time when you wrote it and when you signed it. If you sign it at the top and there's room at the bottom for more things to be added, you raise the risk of suspicion and litigation. And it's still even a little bit more complicated than that. It's important that you list your children, and if you have any deceased children, you list any grandchildren by that deceased child. You don't have to give these people anything, but you need to list them so that the judge will know you didn't forget them. If you don't list them, and if you don't give them anything in the last will and testament, they're probably going to have the right to come into court and claim to be pre-termitted heirs, basically people that you forgot. Not every state has this option, but in Oklahoma, if you do not include a provision for your children or for the offspring of any deceased child, then you run the risk of part of your estate, maybe a large part of your estate, going somewhere that it should not go, somewhere you didn't want it to go, because your wishes are what control here if you do this right. So list your children and any offspring of any deceased child. Next, I would suggest, the law doesn't require, but I suggest that you tell us who you want to have serving as your executor, also known as personal representative, and give me 2 or 3 options to work with. If my spouse is still living, I want her to serve as my personal representative. If my spouse predeceases me or is unwilling or otherwise unable to serve, then I nominate my oldest child. There is no preference of age. It's just an example. I nominate my child, Jane Doe, as my personal representative. But if Jane Doe is unwilling or unable to serve, then I nominate my brother, John Smith, as my personal representative. So you've drafted your last will and testament, you wrote it by hand, you listed your children and any offspring of deceased children. Next, you need to list your gifts. And once again, we'll need some options. I leave my homestead to my surviving spouse, Jane Doe, but if Jane does not then survive me, in equal shares to Bill and Bob and cousin Ned, whoever you want to have it. If any of these 3 don't then survive me, then their share goes to Uncle Bill. Give me some options to work with. If all of these are deceased, then I leave my homestead to First Church on the corner of Main and First Street, and so forth. I leave my grand piano to my oldest child, but if she does not then survive me, to her child or children equally. So give some backup plans, because life's uncertain And if you don't have a terrible diagnosis that's going to take you right away, we need some backup plans. And that's pretty much the extent of what you've got to do. Who's in charge? What do they get? When do they get it? And what's your backup plan for these things? Then we need you to protect this original document. Perhaps put it in your safe. Perhaps put it in a safety deposit box. Perhaps give it to the person you've named as executor and put it in their safe. So do something to protect it, and we'll need to know how to find it when you're gone. So tell your kids where it's at. Tell your spouse where it's at. Tell a few people where to find your last will and testament. If you're really concerned, then there's a statute that allows us to deposit it with the court, but it's a little bit of a hassle. And if you want to change it, it's even more of a hassle. So maybe just put it in your safe and make sure somebody knows where to find it, knows how to get to it if and when the need arises. So at a minimum, do a last will and testament, holographic will. Don't have to spend any money to get this tiny little step towards an estate plan. It's better than nothing. Thanks, guys. And it may not be perfect, but it's something, and it's better than not having anything in your estate planning. If you have questions, call us at the office, 405-733-8686. We have several people here that can answer basic questions. Best of luck to you, and hopefully you won't need this for a very long time.